I have the very distinct pleasure of introducing our next speaker, Ian Hull. Ian is a named partner with Hull & Hull, and his bio is in your materials, so I don't intend to review that. I want to expand upon it because as I reviewed it last night, I realized there's a lot about Ian that doesn't make its way onto this single page. He is a very much sought-after mediator and litigator. He has, for those of you that haven't stumbled upon it yet, he has a very popular website and blog with all kinds of resources for professional advisors. He's appeared at all levels of the court, most recently, perhaps not most recently, but within the last while, at the Supreme Court of Canada in the Moore versus Sweet case involving the issue of unjust enrichment. I asked him for a fun fact about himself so that I could share it with you. On short notice, he came up with the fact that his middle name is Mackersey, which I gather is his mother's maiden name. So with that, I'm going to turn it over to Ian. He's going to be speaking to us on equity, diversity, and inclusion, the initiative that's underway with the Law Society and how it's going to change law firms.
Thank you very much, Melanie, and thank you, everyone. This is a great opportunity and a great honor to be here. In a little different role, I want to talk about the concept of equity, diversity, and inclusion. For us lawyers in the room, it's now a CPD requirement, so it's top of mind in some respects, but I've got some more general observations about what I can add to the equation. I don't know how well qualified I am for the topic in that I grew up about 2 blocks away from here, actually, on Strathallan, and I went to high school about 2 kilometers from there, and I live about 2 kilometers from there. So I've got a square box of about 4 kilometers of experience in living in Toronto, but I do think that there's a lot to be said about this topic area and the importance of it in all of our practices. It's designed in every respect to bring top of mind equity, diversity, and inclusion. It's designed to address internal and outward-facing discrimination and harassment in the workplace. Most of us in the room and tied to professional associations, it's widespread in professions, and it's counterintuitive to us who are running businesses. It seems that we want safe and comfortable work environments. So bringing this as top of mind by the Law Society, but by others is a noble task and one that I think is important. I've done some pretty heavy research into this area because I wanted to learn a little bit more about the academics behind it and some of the thinking, and I'm going to refer to a few comments by some leading articles that have been dealing with the topics. But I thought I'd just take a statistical start of this. So judges, we know judges, all of us have to deal with judges at every level. Just as an interesting set of stats that the Canadian Lawyer put out in May of 2019 in their magazine, there's only 2 provinces with female chief justices, and 0% of chief justices of the province, of any province, have family law background. 7% of judges in the Ontario Court of Appeal are from a visible minority. 0% of judges in the Ontario Court of Appeal are from a visible minority. And the percentage of female judges in Superior Court of Ontario right now is at 32%. Lastly, and interestingly, is the fact that we have about 24% of judges right now of federally appointed judges who are supernumerary. So we have a really stark aging population in the judges community as well. And I think that's in part tied to the fact that the governments of the day are slow in replacing. But all of that tells me, that where even at the leadership level, we have a long way to go in terms of equity, diversity, and inclusion. So I started to think about this. What contributes to workplace harassment, and what are some of the solutions? So unrealistic workloads is a systematic problem in professions. Lack of communication between colleagues, and really lack of supervision, all of which actually contributes to the workplace harassment scenarios. And solutions are all unique to each group. At our firm, we actually have a synergy room where we have a large room where the partners work out of, and we have tables and we have desks and we have opportunities for associates to come in on a daily basis. Not every day, they have their own offices, most of them, to work within a collegial environment. And when there's days that you have to work in a situation with more quiet room and a quiet place, there's also breakout rooms. But that was part of the tools that we were starting to bring together to help us, A, communicate better with our associates and get a better understanding of what was going on day to day with them. But secondly, it enhanced our solutions with regard to supervision. So that's just an illustration, and everyone's got their own solutions, but one that we've had. Common biases. So FIDRIO is a family and ADR related group in which many of us are members of. Just had an equity, diversity, inclusion seminar that I participated, not in speaking it, but it was presented, looked at the materials and worked through. And they talk about some of the categories of gender bias. Bias generally. And the first one, of course, is gender. And the authors, both of the speakers, talked about the fact that there's this concept of prove it again, that men are assumed to be competent and women have to prove it again and again. And that's a workplace reality, and something that, again, if it becomes top of mind, we might be able to better address it in our circumstances. Double standards, the in-group bias, all of those situations bring tension within the workplace, but also do not enhance your inclusive, diverse, and equitable environment. Undermining comments, of course, within the workplace are telltale signs of inappropriate and improper behavior and need to be monitored. One of the tools that the speaker was focusing on was to use the power of the pause. When you actually see a demonstrated comment or an undermining comment of that, for example, just pause. And the easiest way to show that you're not happy with that and it's not a suitable comment is to simply not say anything. Pause and make sure that you have identified directly that comment is something that is not suitable. So one of the fundamentals to the equity, diversity, and inclusion academic world is this idea that we have implicit bias. And that just means we don't have an open mind. And it seems a little a worry for those of us who are in the profession of judgment making. And that's what we all do in this room. And it's an unconscious judgment of people that's occurring. And this is a problem, of course, because we're in the business of judgment, and it can potentially alter our sense of what is reasonable in the circumstances. So these are habits, and they're sometimes difficult to recognize, but to the extent that we understand the concept of implicit bias, I think it helps us go a long way to work through it. And it's a reality in the legal profession and the accounting profession. We are, as the academics describe these professions, both and all through North America, as we are the palest of professions. And we suffer from this diversity crisis. So this lack of clarity as to why is really the problem. And Nicole Neghetti is one of the leading authors down in the US speaking about this, and keeps refocusing the idea that all professions have to address implicit bias. What is implicit bias? And see where we can, through self-reflection, improve. And I think that's really what I'm trying to do a little bit of today. In the time frame, my clock has gone silent on me, and the time frame I want to cover today is this self-reflection. Because the implicit bias, of course, it's rooted in our thought process. It's early age association items that are commonly come together. Logically, we expect them to coexist. Thunder and rain, or gray hair and old age. Those sorts of implicit biases exist and obviously are much more serious in the workplace. So the key is to look at what is the influence of the implicit bias, and what is it, how do we go about deactivating it and encountering the stereotypes of the implicit bias. Because biases are not permanent, and we've all felt that and lived that throughout our own lives. But too often what we do at professional firms is we rely on policies that we've established to think that we're getting over the issues of things like implicit bias, when really at the end of the day we're just paying lip service to the issue if we're just satisfied that we've created a policy and therefore we've solved the problem, which is obviously not the case. It seems to me, and that certainly the theories in the academic world is that we need senior leadership to ensure that diversity is embraced at every level, but embraced at the top level so that direction is given throughout. Tracking efforts across the firm to address equity, diversity, and inclusion issues. And as they say, they look at, what are your judgment merits? And is it time to reconsider our judgment merits? And, easy illustrations is that sometimes I can't understand why my associates don't like phoning the other side. And it's because some of them have grown up in a generation where they never pick up a phone and they never talk to anyone on the phone. They are intuitively uncomfortable about that. Whereas I'm sort of like the style of saying, listen, let's talk to the other side first and then see if we can avoid a blowing up. And that's ties to accountability, but it also ties to my judgment metrics, because I'm like, well, if they won't call someone, that bothers me, and then I'm judging them. Well, maybe the truth is that I have to adapt to the reality that is maybe the best way that they're going to exchange between the issues, and I have to reconsider my judgment merits. So. Human problem solving is basically, it's based on tuition. It seems to me, well, it seems smarter people than me because I learned this. It's tuition based or it's slower and deliberate. And when we sit back and at least take the time that we're talking today about these issues, we can start to address the bias. And while it can be a curse in any work environment, it also can be, in my view, easily managed by some of these ideas, none of which are my own and are from much smarter people than I, in what is a very important area of business management. The last part of this I just want to talk about is I took some direction from, and I couldn't help myself, from the rules of conduct, and the accounting profession has similar kind of language in this. But they directly, in the law study rules of conduct, directly refer to diversity and the special responsibility, and the term special responsibility, and that we have as lawyers and as accountants to respect human rights and not to discriminate. Race, on basis of race, ancestry, place of origin, color, ethnic origin, sex, sexual orientation, gender, and so forth. Disability, marital status. And I think that it really was telling to me anyway, because the term special responsibility is a defined term in the rules of conduct. And it acknowledges that the following. It says, the special responsibility for solicitors and lawyers is that we acknowledge there's a diversity of community of Ontario in whom we serve. And the rules expect that we will respect the dignity and worth of all persons and treat all persons equally without discrimination. So it seemed to me anyway that special responsibility, okay, I know that I had fiduciary responsibilities, I know I've got ethical responsibilities. I think this takes it to another level and a different approach, and that is a special responsibility in the context of equity, diversity, and inclusion. Discrimination. Well, there's no real definition. We had to go to the Supreme Court of Canada. Not me, but someone else went to the Supreme Court of Canada to define it. And it's defined as, the Supreme Court of Canada defined discrimination to include differentiation on prohibited grounds that creates a disadvantage. And those prohibited grounds, of course, are the ones that would naturally come to our mind, things like prohibited grounds such as race, gender, sex, sexual orientation. So the lawyer has the obligation, and the accountant and any professional has the obligation to take reasonable steps to prevent or stop the discrimination. The last definition I just want to cover was that of harassment, and that is really engaging in a course of vexatious comment or conduct that is known or ought reasonably known to be unwelcome. And again, I think those sort of 3 or 4 defined terms help us at least get to the root of what the issue is. Instead of just talking about it in some esoteric fashion, these are tangible descriptions of what should not occur. And of course, the rules of conduct anyway for lawyers require us to avoid any form of discrimination or harassment dealing with other lawyers, colleagues, employees, clients, and the general public. And that seems to me to be an important expectation. So finally, we're going to leave a little time if we have some time for questions too, but an appreciation of how racial, ethnic, and gender stereotypes affect the employment decisions is not just a requirement of the legal profession, it's a requirement of all of us to achieve. And we, as I said at the outset, we want a safe and comfortable work environment, but one that is both just and inclusive. And all of those goals can be achieved by bringing to the top of mind these issues of equity, diversity, and inclusion. So those are sort of my thoughts on the topic generally. And as I say, we've got a couple minutes if anybody has any questions. Jordan's like Donahue. He's running around with the microphone. Oh, that was the part of only my generation would understand that one. All right, seeing no questions, I'll take this opportunity to hand the microphone back to Jordan.